Hi everyone, welcome to Impact Academy. So today let us continue with the Indian Polity important one-liners. Last class we have seen till 100, so today let's continue from 101. So India is called a republic because the head of the state in India is an elected head for a fixed period. So if you look at the British government, it's called a monarchical system of government. Okay, because the British king or the queen, that role is hereditary. So it is a monarchical system, and in a republic system, we have the head of the state who is the president and he is elected for a fixed period. And also, if you talk about democratic, many people get confused what is republic, what is democratic. Okay, so even a republic also there is democracy. Mainly when you call a government democratic, when the people have the right to vote. Okay, so and it is a republic because the head of the president is elected for a fixed period. Keep that in mind. Okay. Sovereignty in a democracy rests with the people. Okay, obvious, right? And remember the preamble. Okay, social, secular, sovereign, democratic, etc. The preamble secures justice, liberty, equality, and fraternity to all its citizens. So already we have seen multiple times, right? The preamble. Okay, if you see the preamble, okay, we the people of India, having solemnly resolved to constitute India into sovereign, socialist, secular, democratic republic and to secure to all its citizens. So we are giving this justice, liberty, equality and fraternity to the citizens. Okay, and what justice? Social, economic and political. Liberty of thought, expression, belief, faith and worship. Equality of status, opportunity and promote among them all fraternity. Okay, dignity of individual, unity and integrity of the nation. And couple of more things you need to remember. 26th November 1949. It was adopted. Okay, frequently we have seen this, right? It is adopted on 26th November 1949. The constitution came into being in 1950, January 26, 1950. That is very important. This word adopt came into force. Okay, that no changes the options. Anyway, so the preamble secures justice, liberty, equality, and fraternity. JLEF. I have to remember. Usually I remember that way. JLEF to all citizens. The preamble of the Constitution indicates the source of the Indian Constitution. So multiple times we have seen this question, right? What is the preamble? It is the what you say. It shows the mind of the makers. Okay, it's the what you say. It's like a soul of the Constitution. All these things we have seen. So basically, the source of the Indian Constitution is also preamble. Okay, the preamble also whenever there is a issue, whenever there is a what is a conflict in court or etc., they even look at the preamble to understand whether it is constitutionally correct or not. So the source of the Indian Constitution, the preamble is one of the source of the Indian Constitution. Next one, not fifth. It is not the objective enshrined in the preamble. Which one? Secure shelter and proper livelihood to all. Okay. So when there are multiple options, then you can make out. So he's probably talking about justice, liberty, equality, fraternity, or you can give support of this. Okay. So among that, there is no such thing as secure shelter and proper livelihood to all. So this proper livelihood, you can say maybe it's part of directive principles of state policy around Article 43, 43A, all those things. Okay. But specifically in the preamble, there is no such thing as shelter and livelihood, etc. So the idea of social, economic, and political justice has been taken from French Revolution. Fine. So for this, let us see the what is it? The source of the Constitution. Just a minute. So if you look at the sources of the Constitution, you can see the French Constitution. We have taken the republic and ideas of liberty, equality, and fraternity in the preamble. Okay, that is from the French Constitution. We have taken these what is it, these features. Okay, republic, ideas of liberty. Always that's why whenever you talk about the French, you talk about liberty, right? Even if you watch like frequently used in movies, also they say they are very liberal. Okay, equality, fraternity, etc. So those are taken from French Constitution, but of course here is asking about the concept of equality and fraternity has been taken. So the idea of social, economic, and political justice has been taken from the French Revolution. Okay, The concept of equality and fraternity has been taken from the Russian Revolution. So this we are talking about the revolutions, not the constitution. Okay, the features have been borrowed from the constitution, and also if you see Russian, you see from USSR, Soviet Union, we have taken the fundamental duties and the ideal of justice, social, economic, and political. Okay, social, economic, and political justice we have taken from the, and also fundamental duties. Fundamental duties we have taken from Russia. So that is from the Russian Constitution, and from the Russian Revolution we have taken the concept of equality and fraternity. Which of the following is described as the soul of the Constitution? I already told you, right? Preamble. Preamble is called the soul of the Constitution, and many other things. All those things are important. So, which of the following is not treated as part of the Constitution? Fundamental duties. Okay. So, if you look at what is taken as part of the Constitution, then you obviously get fundamental rights. Okay, the preamble and the directive principles of state policy, etc. All those things. And whether the preamble is part of the Constitution or not has also been a matter of debate. Okay, in some judgments we have that preamble is not a part, and then whether preamble can be amended or not. All those things. If you look at the evolution of Constitution, then we'll get a better idea. Okay, so which of the following is not treated as part of Constitution is the fundamental duties. Next, democracy of India rests on the fact that people have the right to choose and change the government. Fine, that is what is called as democracy. People have the right to choose and change the government, and this usually happens through several, we have the general elections, of course, but also there are others like referendum, plebiscite, etc. So in India, most of the time we see only direct elections. Okay, we don't see referendums, etc., plebiscites, all these things that happen. But in other countries, those things are also frequently used, especially to decide about various policy decisions, etc. Okay. But in India, it is usually not like that. Either there are direct or indirect elections, and the elected representatives look after the policy making and everything. So the word democracy is derived from the Greek words demos and kratos. Fine, remember that demos and kratos. India opted for a federal form of government because of linguistic and regional diversity. So, in the question, there could be several options. They might say different types of what you say racial diversity or several other things. But majorly, India opted for a federal form of government mainly because of linguistic and regional diversity. Because though India is one country, every 100 kilometers in any direction you go, the language keeps changing and the food habits keep changing, etc. So we have a lot of linguistic and regional diversity. So we opted for a federal form of government. What is the chief source of political power in India? As we said, it is the India is a democracy. So for the people, by the people. The people have the supreme authority through what you can say elections. When the election comes, it is the people who elect the representatives. So a flexible constitution can be amended easily. Ours is not a very flexible constitution because even though we have Article 368, okay, Article 368 is there, but see, for example, in the first, what is it, Shankari Prasad case, 1951, the constitutional validity of the First Amendment Act, which was changed. So what happened was, when the constitution came into being in 1950, okay, 1950, right to property was a fundamental right. So the government, because India needs rapid development, because by that time we had been under British rule for so long, most of the land belonged to few people, Jamindars, etc. So hundreds of acres of land was under the name of one person. So we brought in, the government has brought in the land ceiling reforms, etc. That is, each person should have only say 2 acres of land under his name, 10 acres of land based on the type of land, etc. All these things. So when these land reforms have come, many people have gone to the court saying our right to property has been violated. So what they did was they brought in the First Amendment and they put all these laws, land ceiling laws, everything in the First Amendment, so that people cannot challenge in the courts. Okay, so that is what happened in this Shankari Prasad case. And Supreme Court said that the right to amend the Constitution also means to amend the fundamental rights, because right to property has been removed, right? It has been removed as a fundamental right and made a legal right under Article 300A. Next came the Golaknath. These dates are also very important because frequently questions will be asked, match the following, etc. Then or keep in ascending order, something like that. Only if you remember the dates, you will be able to solve such questions. So this Shankar Prasad case came in the 1951. So first case, Shankar Prasad. Next, Golaknath case. In this case, the Supreme Court said that fundamental rights are given transcendental and immutable position. Hence, Parliament cannot abridge or take away any of these rights. So, this is very important because in Golaknath case, Supreme Court said fundamental rights cannot be amended. For that, the government came up with the 24th Amendment Act of 1971 as a challenge to this. It said that no, Parliament has the power to abridge or take away the fundamental rights also under Article 368. So remember this. I mean, questions can be asked. When did the Supreme Court say that fundamental rights cannot be amended? Golaknath case, 1961. And what the government did? 24th Amendment Act of 1971. After that, the Keshwan and the Bharti case, 1973, which is the landmark. Okay. In this, what the Supreme Court has done is what you say overruled the Golaknath case. So in Golaknath case, it said fundamental rights cannot be amended. In Keshwananda Bharti case, it said fundamental rights also can be amended. Okay, and it upheld the 24th Amendment Act. And also, it laid down the doctrine of basic structure. So this question is also frequently asked. Which of the following case, under which case the Supreme Court had laid down the doctrine of basic structure? So options will be Golaknath case, Keshwananda Bharati, Minerva Mills, etc., etc. So it is Keshwananda Bharati case. So in the famous Keshwananda Bharati case itself, 1973 is also important. The Supreme Court has laid down the doctrine of basic structure. Then the 42nd Amendment Act of 1976, which I am sure everyone is aware, it is during the period of emergency, the what you say, Congress government in this is called as the mini constitution, and Swaran Singh committee on whose recommendations the fundamental duties have been what is a proposed, and all those things comes under 42nd Amendment Act of 1976. And what this act says that there is no limitations of parliament and no question shall be asked in court. So always the parliament will try to increase its powers. Okay. Then Minerva Mills case is the 1980. So it is what you say. So if you remember this, Shankar Prasad 1951, Minerva Mills is 1980. So if out of say 5 options are given, you can see you can put Shankar Prasad case in the beginning and Minerva Mills in the end. Then you will get the rest of the order automatically. So at least try to remember these two things. And in the Minerva Mills case, judicial review is also basic structure. Fine. And these are the what is the basic structure: supremacy of the constitution, sovereign democratic republic in nature, okay, and secular character, separation of powers between legislature, executive, and judiciary. Article 50, right? Federal character, you cannot change that. Unity, integrity of the nation. So no state can say I will. I will secede from the nation. It's not possible. Okay, welfare state. Okay, welfare state is also no state government can say I will stop giving free rice, free ration, etc. Because that is one of the basic structure. Because India is a poor country, I mean there is significant amount. Though India is a rich country, there is significant amount of population, number of population who are very poor. So this welfare state is also very important for India. Judicial review, again, many times you see no question shall be asked in court, etc. All these things, and also we have seen the National Judicial Accounts Committee, all those things. So all these things will be struck down. They'll be struck down by the courts because judicial review is a fundamental. What you say, it's a basic structure of the constitution. So freedom and dignity of the individual, okay, parliamentary system, rule of law, fundamental rights. All these are basic structure of the constitution, and that came in Keshwananda Bharati case. Try to remember that. So a flexible constitution can be amended easily. In our case, Article 368 is what used to amend the constitution, but it is a limited power and there are restrictions. So ours is not a complete rigid or complete flexible. Ours is a mix of both. So the judiciary acts as the guardian of the constitution in a federal government. Okay, remember that in the federal government, ours is also a federal type of government. Judiciary acts as the guardian of the constitution. Fine, because we have a unified judiciary. Okay, all the high courts and all they all work under the same judiciary. Supreme Court is the supreme, and you have every state has a high court followed by district courts, etc. So look at 116. India is a secular state because it is described so in the preamble of the constitution. Fine. So I mean it depends. If you have four options and one of the option is this, then it is India is a secular state. Okay, try to remember that, and it is written in the preamble of the constitution. Our constitution has laid emphasis on securing social, economic, and political justice to all the citizens of the country. These objectives are aimed at securing a welfare state. Okay, welfare state is one of the what is the important directive principles of state policy, and every state follows this, right? Every state has some form of subsidy or what is say some form of um, free ration, free food grains, okay, and free. If you take Andhra Pradesh, you have all these things. Welfare state means Amavadi comes under welfare state, and giving this free ration comes right bharosa. All these things come under welfare state. Okay, modern states are generally considered as welfare states. No state can afford not to give these things. Okay, a state which does not promote or interfere in the affairs of religion is referred to as secular. Usually, this is the kind of secularism that is followed in the United States and some of the European countries, where the state does not promote or interfere in the affairs of religion. But in Indian secularism, what you can say, the state, it is you cannot say that it does not interfere. It is more like the state treats all religions equally. Okay, because we have temples under the control of the state, and funds will be given to the temples, and funds will be given for this what you say hajj trips, etc., and several issues. So basically, the state tries to it actually interferes in the affairs of religion and tries to treat all religions equally. So that is the kind of secularism we have in India. So try to observe the difference. Okay, in United States, etc., the state does not interfere completely in the religion. Okay, the constitution is a dynamic law, especially because we have Article 368, and it is said that I mean in the constitutional debates, the Constitutional Assembly, even Dr. B.R. Ambedkar has said that a constitution has to be dynamic. What is a dynamic law? Okay, because it has to adjust itself to the changing needs and times. So that's why we have Article 368, Amendment of the Constitution. The Constitution of India provides for single citizenship. So in countries like Canada or what you say, I mean the United States, etc., you have dual citizenship. You have one citizenship of the country, one citizenship of its respective state also. But here in India, we have a single citizenship. The Constitution provides powers, responsibilities, and limitations also. Okay, it gives the powers to the legislature, executive, etc. It also gives them responsibilities, and there are limitations also. Especially if you look at fundamental rights, okay, they are considered as limitations on the state because we have the right to equality, right to speech, etc. That means it is the limitation on the state. Okay, such questions are frequently asked, and you have to remember. See, directive principles of state policy are like empowering the states. They are saying the states do this, do that. But in case of fundamental rights, they are limiting the state. Okay, the state cannot do whatever it wants. We have our rights. Okay, try to observe the difference because the such questions are frequently asked. And usually people may get confused. If you say the fundamental rights are limiting the state, they'll think fundamental rights are something positive. Why is it used in a negative sense? But no, the fundamental rights are actually limiting the state. The fundamental organs of the state are established by the constitution. Okay, because see, if you look at all these constitutional bodies, what is say National Commission for Scheduled Caste, Scheduled Tribes, or the UPSC, APPSC, etc., and all these constitutional bodies, Election Commission, position, Office of President, Vice President, everything, okay, Prime Minister, all these things, all the constitutional bodies are defined in the established by the Constitution itself. Detailed provisions regarding acquisition and termination of Indian citizenship are contained in Citizenship Act of 1955. Fine, passed by the Parliament. Citizenship Act of 1955, and we've already seen. So, if you look at citizenship, so observe this: rights only to citizen and rights to aliens. So, citizens enjoy all the civil and political rights, Article 15, 16, 19, okay, and see Article 15, which is right against discrimination on grounds of religion, race, caste, etc., place of birth, etc., is not available for the aliens. Aliens means basically who are foreigners, okay, who are not citizens of India. If they are from Pakistan or any country with which India is at war, they are called as enemy aliens. Otherwise, they are called as aliens. So Article 15 is not there, but 14 is there. So this is very important. Observe this. What is there, what is not there? Because frequently questions are asked. See, Article 14 is right to equality. So even if you are a foreigner, you have to treat them with equality, right? It is, and see Article 19. Okay, Article 19 is right to freedom of speech and expression. Okay, movement. So if a foreigner comes to India, he cannot say that I have the right to freedom and speech and expression. I have assembly. I mean, 10 of us will come together and we can make any protest or anything. All these things are not available to the foreigners. And 29 and 30, 29 and 30 are cultural and educational rights. They are regarding the language of the minorities, the culture of the minorities, etc. So they are foreigners, right? What we cannot encourage their culture also. So they do not have such rights. But other rights of equality, Article 14 equality, 17 untouchability, and you have this especially 2021, that is right to detention, right to life and liberty. So all these things are available to foreigners also, because life and liberty is not something because there is a foreigner you simply cannot take away. So observe this. What are articles which are not available to the aliens? Article 15, 16, 19, 29, 30. So try to remember why. Then you will understand. Okay. 15, 16, because we are talking about opportunity in matters of employment. So foreigner cannot come and say, I want employment. I mean, I have the right to employment. Okay. And 15 is discrimination based on these things. And 19 is because assembly, association, movement, residence, profession. Okay. So those rights are also not there. And we are talking about, but at the same time, if you observe, you have the right to what is right to religion 26, 27, 28, all these things, right? So even if you are a foreigner, you have the right to follow your own religion. So try to remember in that sense, then you will be able to understand better. However, enemy aliens do not enjoy protection against arrest and detention in Article 22. So enemy aliens means mostly from those at which we are at war, like maybe Pakistan or any other country with which we have troubled relations. Those are called as enemy aliens, and such people can be arrested and detention because they are a threat to the nation. In India, both a citizen by birth as well as a naturalized citizen are eligible for the office of president. Okay, both citizen by birth and naturalized citizen also. That means even though he is not born in India, and there are several ways to get Indian citizenship, right? So if you have from outside and you have stayed here for the say 10 to 15 years and you have become a naturalized citizen, even then you are eligible for the office of president. But in USA, only it has to be a citizen by birth. Okay. So many people come from abroad, settle down in the US. They cannot become president. You have to be born there. Okay, and the right to vote in elections, foreigners don't have the right to vote in elections. Right to contest to become an MP or MLA, they don't have. And the eligibility to hold public offices like president, vice president, judge, etc., attorney general, all these things. So obviously if you use a little bit of common sense, you can say that foreigners will not have those rights. So this is very important. Okay, so when we talk about citizenship, it is from article 5 to 11 and it is under part 2. 5 to 11, remember that. It only identifies the persons who became citizens of India at the commencement, that is 26 January 1950. It does not have any permanent or elaborate provisions. Okay, it does not deal with problem of acquisition or loss of citizenship. Next, empowers the Parliament to enact a law or matter relating to citizenship. So, Parliament has the right to enact laws relating to citizenship. So all these things just these are also important. If you look at Article 5, should be born in India or one of his parents was born in India or he has been ordinarily resident in India for 5 years immediately before the commencement of the Constitution. So before 1950, if you have been in India for 5 years, then you are a or you are born in India, or your parents are born in India, that is, you are a citizen of India. A person who migrated to India from Pakistan, or if either of his parents or any of his grandparents was born in uninvited India and fulfill any of the two conditions. He migrated to India before 1948. He had been ordinarily resident in India since the date of his migration. Okay, so before 1948, you have migrated and you are residing in India. He migrated to India before 1948 and had been resident in India since the date of his migration. Residence for 6 months before registration. So before 1948, if you have come from Pakistan or anywhere and you have settled down in India, even then you are getting Indian citizenship. That is Article 6. So Article 7, person who migrated from Pakistan to Pakistan from India after 1947 and returned to India for resettlement. So from here you went there, but again you came back. Okay, and he has to be in India for 6 months before applying for it. And Article 8 covers overseas Indians who may want to acquire Indian citizenship. Okay, basically persons of Indian origin. So even though you were born outside, you have Indian heritage. So you can apply if your parents, grandparents, etc. are Indians. You can apply. So Citizenship Act of 1955 is also very important. So how do you get the citizenship? By birth. Okay, person born in India on or after January 26, 1950, but before July 1st, 1987 is a citizen of India by birth. Okay, and born in India after 1987, you can become citizen only if either of the parents is a citizen of India at the time of his birth. Born in India on or after December 3, 2004 are considered citizens of India only if both their parents are citizens of India. So try to remember all these points. Children of foreign diplomats posted in India cannot acquire Indian citizenship by birth. So if you are working in the British embassy, you are a yeah, what you say, you are British citizen and working here in embassy, and here you have kids. They will not get Indian citizenship by birth. Okay, either of the parents has to be citizen of India, and by descent. This we are talking about by birth. If you are talking about by descent, persons born outside India after January 26, 1950, but before 1992 is a citizen of India by descent. If his father was a citizen of India at his time of birth. Okay, December 2004 onwards, person born outside India shall not be a citizen of India by descent unless his birth is registered. Okay, so that is by descent. Fine. By registration. So anyone can apply to become a citizen of India, and he should not be illegal migrant. He is ordinarily resident in India for 7 years. So remember this. If you want to apply for Indian citizenship, you have to be a resident of India for 7 years. Person who is married to a citizen of India and residing for 7 years. So you marry someone from India and reside here for 7 years. And also, if you are registered as a OCI, okay, overseas citizen of India card holder for 5 years, and who is ordinarily resident in India for 12 months. So you can be a overseas. So your parents have migrated to US and you have applied for overseas citizenship, and you have that for 5 years, and then for 12 months before applying, you are in India. Then also you can become citizen of India by naturalization. Okay. So if you want to become citizen by naturalization, you have to come from a country where that country does not prohibit citizens of India from becoming their citizens. Okay, he undertakes to renounce the citizenship of origin country. So India does not allow for dual citizenship. Try to remember this. There has to be only one citizenship. So, for example, you are coming from, say, some African country and trying to become a citizen of India, then you have to renounce your citizenship of that country. Okay, he has resided in India or in service of a government of India. He is of good character, adequate knowledge of language specified in the 8th schedule. That means either one language of the 22. By incorporation of territory. So, see, incorporation of territory. For example, when Pondicherry became part of India, okay, then all the people residing in Pondicherry, they also become citizens. And special provisions as to citizenship of persons covered by the Assam Accord, which related to the foreigners issue. So this Assam Accord is also very important. All persons of Indian origin who came to Assam before 1966 from Bangladesh who have been ordinarily residents in Assam since date of their entry into Assam shall be deemed to be citizens. So that is before 1966. So who came to Assam after 1966 but before 97 from Bangladesh, who have been ordinarily resident in Assam since date of his entry into Assam, who has been detected to be a foreigner shall register himself. So this CAA is also you have some regarding the CAA, you have some opposition from Assam because it is Assam. In the Assam, people don't want foreigners to come and settle down in Assam because they will lose their culture. So this Assam Accord is also very important. So many people are against CAA in Assam because of this only. Because the CAA Citizenship Amendment Act is going to give rights. Okay, it's going to give citizenship to people who have come from Bangladesh, etc. Okay, from nearby countries, and they will settle in Assam. And they don't want it. They don't want to lose their unique culture. So this is very important. 1971, March 25th, 1971. Who came before that? Okay, only are eligible to be citizens according to the Assam Accord. Okay, and also this is important, frequently asked. How do you lose the citizenship? By renunciation. Any citizen of India of full age and capacity can make a declaration renouncing his Indian citizenship. But if that such a thing is made during a war, then that registration can be withheld by the central government. So under normal circumstances, you can renounce it. But if, for example, your parents have renounced the Indian citizenship, but because you are of Indian heritage, if you are a minor child of the person at that time, then when you become 18, then you have the right to again get back Indian citizenship. Because you are of Indian heritage, your parents have renounced, but you want to become citizen of India, you can become. By termination, when an Indian citizen voluntarily acquires the citizenship of another country, then his Indian citizenship is automatically terminated. Very important. Understand this. And does not apply during a war in which India is engaged. Fine. By deprivation. So, if you have obtained citizenship by fraud, okay, or you have shown disloyalty to the constitution, and you have communicated with enemy during the war, and the citizen has within 5 years after registration or naturalization has been imprisoned in any country, other country for 2 years, or the citizen has been ordinarily resident out of India for 7 years continuously. So all these things, if you do all these things, then you will be deprived of your citizenship. So this question is also frequently asked: deprivation, termination, and renunciation. So OCI card, etc. All those things, fine. Now let us look at the question. Okay, so we have seen everything about Indian citizenship, and this is the Indian Citizenship Act of 1955. Fine. Who, which of the following is not a condition for becoming an Indian citizenship? Acquiring property. Just now we have seen, right? Acquiring property, simply by acquiring property, you cannot become a citizen. So we have seen what are the ways: by birth, by descent, by naturalization, by registering, etc. All those things. So a person can lose citizenship through deprivation, termination, and renunciation. Okay, we have seen just now. Renunciation is voluntarily giving away. Deprivation is communicating with enemy aliens during war and all those things. Residing outside India for 7 years and obtaining citizenship law illegally or showing disloyalty to the constitution. So that is deprivation. Termination. Okay, termination also we have seen just now. Renunciation. Okay, giving away voluntarily. Fine. So the aims and objectives of the Constitution have been enshrined in the preamble. Okay. So the Office of the Governor General of India was for the first time created under Regulating Act of 1773. So we have seen, right, all these regulating acts and the Councils Act, Charter Acts, all those things multiple times we have seen. So Office of Governor General of India was for the first time created under Regulating Act of 1773. Okay. See. Uh, for the first, see, in 1773, the governor of Bengal has become Governor General of Bengal. Okay, and who is the first Governor General of Bengal? Warren Hastings. So this is Governor General of Bengal. So in the question, you can see the office of the Governor General of India. This is wrong. This is not 1773. If you are talking about regulating that, it is Governor General of Bengal. So that's why I got doubt. It is 1833, I believe. Let's see. See, in 1833, Charter Act of 1833, the Governor General of Bengal became the Governor General of India. Lord William Bentinck is the first Governor General of India. So we have seen this multiple times, right? So there is a slight mistake here. It is not Regulating Act of 1773. Office of Governor General of India, okay, is 1833. Charter Act of 1833. If you are talking about Regulating Act of 1773, it is Governor General of Bengal, okay, not India. So according to the Act of 1858, which is after the revolt, right? Government of India Act of 1858, territory was divided into provinces. Okay, the Bombay province, Chennai province, Assam province, and northwestern frontier, all these things. Okay. When did the British Crown assume sovereignty over India from East India Company? After the revolt of 1857, through the Government of India Act of 1858, the British Crown had assumed sovereignty over India. Parliamentary reforms, Councils Act of 1909. Okay, these things we have seen multiple times, right? Very basics. Okay, see, parliamentary reforms means Indian Councils Act of 1909, and for the first time, elections to legislative councils, and separate electorate for Muslims. Okay, and Association of Indians with the executive councils of the Viceroy and Governor. Sachendra Prasad Sinha became the first Indian to join the Viceroy's Executive Council. And here in 1919, it introduced a responsible government, created Office of High Commissioner of India, and Indian legislature became bicameral for the first time in 1919. And communal representation had been extended. Here it is only for Muslims. Now it is for Sikhs, Christians, Anglo Indians, etc. All these things we have seen multiple times. Okay. So parliamentary reforms 1909 and 1919 Councils Act of 1919 is Montague transport reforms. Okay, that also we've seen. Under which of the following act was provisional autonomy introduced in India? It's in the C, provisional autonomy. If you look at this, 1919 and 1935, you have to see diarchy in provinces. Okay, diarchy in provinces was introduced in provinces in the 1919. In 1935, what they have done is diarchy has been abolished in the provinces. Okay, in the provinces, that means states. Okay, in the states, diarchy was removed and it was kept in center. Very important. In 1935, diarchy is removed in the provinces and in its place, provincial autonomy has been kept. And this diarchy has been introduced in the center. They have taken it out from the state but introduced in the center. That is frequently asked. And provincial autonomy is there. Okay. So provincial autonomy has been introduced through the Government of India Act of 1935. So who made the Constitution of India? The Constituent Assembly. Okay, obviously, right? We have the Constituent Assembly, and there are several questions on Constituent Assembly also. We have seen how many days, how many, from what time to what time, who are the members. Okay, drafting committee, chairman Dr. B.R. Ambedkar, all those things. The Constituent Assembly is convened to frame the constitution of the country. Okay, which is obvious. The Constituent Assembly was set up under the Cabinet Mission Plan of 1946. So, before giving independence, we have this series of what is a Cabinet Mission Plan, Wavell's Plan, Shimla Conference, all those things. Try to remember them in a proper order. And the Constituent Assembly was set up under Cabinet Mission Plan of 1946. Very important. Which party was not associated with the Constituent Assembly? The Communist Party. Okay, the Communist Party did not join the Constituent Assembly. The Republic of India, established by the Constitution, is sovereign, socialist, secular, democratic. Okay, all those things are there, right? Secular has been added, secular and integrity. All these things have been added by the 42nd Amendment Act. The mind and ideals of the framers of the Constitution are reflected in the preamble. Okay, we have seen many days. It's the soul of the Constitution, and it's the source of the power of Constitution. The mind and ideals of the makers of the Constitution. All those things. So in our constitution, what justice is not given to the citizens? So we've seen, right, in the preamble, justice of okay. So what justice? Justice of social, economic, and political. Okay, social, economic, political, not technical. So this plan, this what you say, this is the old one. You can remember the 5-year plan is 2002 to 2007, and obviously today there is no planning commission. It has been replaced by the Niti Aayog. Anyway, so amend means remove the difficulties. Enact means pass along. So try to observe the difference. Who advocated Grama Swarajya for the growth of villages? This is obviously Gandhi. Even Directive Principles of State Policy, you see Article 40, and there are several articles which are come under Gandhian principles. Article 40 is regarding village panchayats, etc. That is part of Grama Swarajya. Purna Swarajya was declared as the goal of the Congress 1929 Lahore session. Okay, it's frequently we have seen 1929 here 1929 Lahore session. Lahore session complete independence. Okay, Purna Swaraj. Lahore session presided by Jawaharlal Nehru passed the resolution on Purna Swaraj. Our constitution prohibits untouchability through Article 17. Okay. Constitution declared India as a republic on 26 January 1950. So, where the constitution came into force. When was it adopted? November 26, 1949. Very important. So, who has given the following statement? Democracy means the government of the people, by the people, and for the people. It is Abraham Lincoln. Okay, this statement we've heard many times, right? For the people, by the people. That was given by Abraham Lincoln. Which one of the following features was borrowed by the framers of the Constitution from the US? Okay, so we've seen sources of the Constitution, right? So sources of the Constitution. So from the US, we have taken the fundamental rights, independence of judiciary, judicial review, impeachment of the president, removal of Supreme Court, High Court judges, and post of the vice president. So removal of judges, judicial review, fundamental rights, okay, impeachment of president, Supreme Court judges, all those things, post of vice president, etc. So last question for today. The ideals of liberty, equality, and fraternity. Okay, liberty, equality, and fraternity enshrined in the preamble have been taken from the French Revolution. Always I told, right, French they are very liberal, equality, okay, fraternity. All these things have been taken from the French Revolution. Fine, that's all for today. Thank you.